Start. It is tried that the courts and tribunals having plenary jurisdiction have discretionary power to grant an appropriate relief to the parties, full stop. The aim and object of the Industrial Disputes Act may be to impart social justice to the workman, but the same by itself would not mean that irrespective of his conduct a workman would automatically be entitled to relief, full stop. The procedural laws like estoppel, waiver and acquiescence are equally applicable to the industrial proceedings, full stop. A person in certain situation may even be held to be bound by the doctrine of sub silentio, full stop. The respondent herein did not raise any industrial dispute questioning the termination of her services within a reasonable time, full stop. She even accepted an alternative employment and has been continuing therein from 10.8.1988, full stop. In her replication filed before the presiding officer of the Labour Court while traversing the plea raised by the appellant herein, it was averred that she is gainfully employed with effect from 10.8.1988 and her services be regularized, full stop, para. It is true that the respondent had filed a writ petition within a period of 3 years, but indisputably the same was filed only after the other workmen obtained same relief from the Labour Court in a reference made in that behalf by the state, full stop. Evidently in the writ petition, she was not in a position to establish her legal rights so as to obtain a writ of mandamus directing the appellant herein to reinstate her in service, full stop. She was advised to withdraw the writ petition, presumably because she would not have obtained any relief in the said proceeding, full stop. Even then, High Court could have dismissed the writ petition on the ground of delay or could have otherwise refused to exercise its discretionary jurisdiction, full stop. The conduct of the appellant in approaching the Labour Court after more than 7 years had therefore, being considered to be a relevant factor by the Labour Court for refusing to grant any relief to her, full stop. Such a consideration on the part of the Labour Court cannot be said to be an irrelevant, full stop. The Labour Court in the aforementioned situation cannot be said to have exercised its discretionary jurisdiction injudiciously, arbitrarily and capriciously, warranting interference at the hands of the High Court in exercise of its discretionary jurisdiction under Article 226 of the Constitution, full stop. Para. It is also relevant to note that there may or may not now be any regular vacancy with the appellant bank, full stop. We have noticed herein before that in the year 1996, the vacancies had been filled up and a third party right had been created, full stop. It has not been pointed out to us that there exists a vacancy, full stop. Having considered the equities between the parties, we are of the opinion that it was not a fit case where the High Court should have interfered with the discretionary jurisdiction exercised by the Labour Court, full stop. For the reasons aforementioned, the impugned judgment cannot be sustained, which is set aside accordingly, full stop. This appeal is allowed, full stop. However, in the facts and circumstances of the case, there shall be no order as to costs, full stop. फ्रेंड्स, ये हुआ है 350 में, ठीक है. तो ये 120 प्लस की स्पीड है. और ये डिक्टेशन कैसा लगा आपको बताइएगा. इसको ज़्यादा से ज़्यादा लाइक और शेयर करिएगा. सब्सक्राइब तो करना भूलिएगा मत, क्योंकि इसमें पैसे नहीं लगते हैं, ये फ्री है बिल्कुल. और इसके बाद जो एक बेल आइकन आती है उसको प्रेस कर दीजिएगा, ताकि जो भी डिक्टेशन डाला जाए जनरल या लीगल, वो आपको उसकी इंडिकेशन आपके यूट्यूब इनबॉक्स में मिल जाएगी, ठीक है. जिससे आपको प्रैक्टिस करने में आसानी होगी, आपको पता चल जाएगा डिक्टेशन आया. तो चलिए फिर अगली डिक्टेशन में मिलेंगे. थैंक यू.